Okay, Assalamualaikum warahmatullahi taala wabarakatuh. My name is Muhammad Zaki bin Muhammad Zani, and today our group will talk about subcontract. For the first topic is subcontract and assignment. What is subcontract? Subcontract is the practice of assigning or outsourcing part of the obligation and task under a contract to another party as known as subcontractor. There are two types of subcontractor. The first one is domestic subcontractor. Domestic subcontractor is the type of subcontractor that appointed the main contractor himself to do special work for a project. The second one is nominated subcontractor. The nominated subcontractor is the subcontractor that selected by the client itself to handle the special work for the project. Next is about the subcontractor and assignment based on PWD 203A. In clause 47.0, the first clause is 47.1. The contractor shall not without the prior written consent of the SO, which consent shall not be unreasonably delayed or withheld, subcontract the design for any portion of the work under clause 22 of this contract where the SO consents to any subcontract under this clause. Such consent shall not in any way absolve the obligation of the contractor under clause 10. Based on the clause 47.1 said that if the main contractor does not have written consent from the SO, the subcontractor cannot start to do the work. So based on clause 47.1 ni, jika Menkon tidak mendapat permission atau kelulusan bertulis daripada SO, maka Menkon tidak dapat memberikan kerja kepada subkon. Next is 47.2. The contractor shall not subcontract the whole or any substantial part of the works without the prior written consent of the SO, which consent shall not be unreasonably delayed or withheld. Any such consent is given shall not relieve the contractor from any liability or obligation under this contract, and he shall be responsible for the due observance by such subcontractors of all the terms, stipulations, and conditions under this contract. So based on 17.2, the main contractor cannot give any work for the subcontractor if the main contractor does not have any written permission from the SO. So clause 47.2 ni dia lebih kurang sama dengan clause 47.1, iaitu jika Menkon tidak dapat permission bertulis daripada SO, maka Menkon tidak dapat membahagi kerja secara wholly ataupun partially kepada subcontractor tersebut sebab dia tak ada permission. Next is 47.3. Notwithstanding any subcontract made pursuant to clauses 47.1 and 47.2, the contractor shall be fully responsible for the acts, defaults of neglect of any subcontractor, including labor only, subcontractors, his agents, servants or workmen, as if they were the acts, defaults or neglects of the contractor, his agents, servants or workmen, provided that the provision of labour on a piecework basis shall not be deemed to be a subcontract under these clauses. Based on the 47.3, main contractor have fully responsible on the subcontractor in the work that they do. So maksudnya clause 47.3 ni, Menkon ni mempunyai tanggungjawab, memegang semua tanggungjawab, iaitu dari segi subkon, pekerja subkon ataupun payment, semua bertanggungjawab di atas Menkon. Next is the clause 47.4. It shall be a condition in any subcontract which has been consented by the government that upon termination of the contractor's employment under the contract, the employment of the subcontractor under the subcontractor shall terminate immediately. no claim whatsoever shall be made by the contractor and or subcontractor against the government for any work done or materials or goods supplied. Based on the clause 47.4, if the main contractor had been eliminated, automatically the subcontractor will be eliminated and the materials and supply of the goods cannot be claimed. Maksud 47.4 ni, maksud clause-nya iaitu jika main contractor membuat satu kesalahan yang melibatkan sampai klien terminate main contractor tersebut, maka secara automatik subkon akan terminate juga, dan apa-apa kerja yang telah dibuat oleh main con atau subkon tidak boleh diklaim. Subkon atau main con tidak dapat mengklaim bayaran tersebut atau kerja yang dibuat daripada klien. Next is 47.5. If the contractor subcontracts the works in whole or in part in any person without getting prior written consent of the SO, as provided under this clause, the SO shall have the right to instruct the contractor to forthwith terminate such subcontract, and the contractor shall be liable for all costs and expenses relating to such termination. Based on clause 47.5 state, if the main contractor give the subcontractor work without consent or permission from the SO, the main contractor will be terminated by the client and automatically the subcon will be terminated as well. So maksud clause 47.5 ni dia lebih kurang sama dengan 47.4, iaitu bila Maincom membuat kesalahan yang besar, iaitu kalau dalam clause 47.5 ni, jika SO dapat tahu bahawa Maincom memberi kerja kepada subcontractor tanpa mendapat kelulusan bertulis daripada SO, maka Maincom tersebut akan diterminate. Tetapi apa-apa bayaran yang melibatkan hasil kerja pada subkon itu, subkon berhak untuk meminta bayaran balik daripada main contractor. So clause 47.6, the contractor shall not assign the contract or any part thereof or any benefit or interest therein or thereunder otherwise than by way of assignment in favour of the contractor's banker or any financial institution or corporation of any monies due or to become due under this contract without prior written consent of the SO. Clause 47.6 state that if the contractor must assign according to the SO regarding financial issue, maksudnya jika subkon ada terlibat dengan bayaran daripada main contractor dari segi financial, maka main contractor seharusnya mendapatkan permission daripada SO dulu. Next is about the subcontractor and assignment based on PAM 2018. So the clause that related to the subcontract and assignment is on clause 17. At the clause 17.1 state that other than assigning his rights, interests or benefits under the contract to his financial institute, the employee shall not without the written consent of the contractor, such consent shall not be unreasonably delayed or withheld, assign the same to other parties. Based on the clause 17.1, if the employee wants to do anything, the employee must write a written consent or permission from the main contractor. So clause 17.1 ni menyatakan bahawa jika employee ingin membuat sesuatu atau ingin merequest sesuatu, employee tersebut mestilah membuat permission bertulis ataupun written consent kepada kontraktor untuk mendapatkan kebenaran. assigned by contractor, which is clause 17.2, other than assigning any payment due or to become due under the contract to his financial institution, the contractor shall not, without the written consent of the employee, such consent shall be at the sole discretion of the employer, assign his right, interest or benefits under the contract to another parties. Clause 17.2 state that the main contractor is responsible for all the work and payment for the subcontractor. The main contractor also must make a written report for the SO before giving any work to the third party. Maksud clause 17.2 ni, kontraktor ni bertanggungjawab untuk semua, iaitu dari segi pembayaran subkon, dari segi pengambilan subkon, dan juga main kontraktor ni bertanggungjawab untuk meminta written consent ataupun permission bertulis daripada SO sebelum memberi kerja kepada subkontraktor. Next is no subcontracting. That is clause 17.3. Except where otherwise provided by the contract, the contractor shall not wholly or substantially subcontract the works, where the contractor subcontracts labor only of customer scale or semi-skilled workmen to carry out any portion of the works. This shall not constitute subcontracting within the meaning of this clause. Based on the clause 17.3, if the contractor just using a craftsman, skilled or semi-skilled workman to a certain work does not contribute as a subcontracting. Maksudnya jika Mincon memberi satu kerja atau memberi satu bahagian kerja kepada salah seorang craftsman, skilled or semi-skilled workman, untuk membuat satu kerja sahaja, tidak dikira as subcontracting.
Hello, my name is Siti Nurhaliza binti Muhammad Hafiz. I would like to present for the nominated subcontractor and supplier. Nominated subcontractor is appointed by SO to perform certain works that are generally expert works which have been provided in the tender document or list of prime cost sum and for purposes of implementing part of the work from the whole project. For example, lift and conveyor installation, electrical installation, communication installation, fire protection installation, and etc. For nominated supplier of building materials appointed by SO to supply certain building materials that have been provided in the tender document or list of prime cost sum and for the purposes of supplying building materials to the main contractor for a project. Now I will explain what is nominated subcontractor based on PWD form in clause 60. Clause 60.1 stated that the SO shall obtain tender for nominated subcontractor or nominated supplier work or services or for the supply of materials or goods. The contractor shall, on the written instruction of the SO, enter into such subcontracts with the nominated subcontractor or nominated supplier. Based on clause 60.2, the SO shall not nominate as a subcontractor or a supplier in connection with the works. The main contractor make objection in writing within 21 days after the instruction to enter the site with the nominated subcontractor. The nominated subcontractor do not accept term and condition. And the last one, the nominated subcontractor do not give the government the required indemnity. Based on clause 60.3, the SO shall do one or more of the following alternative, which are nominate an alternative subcontractor or supplier. The works of services may be provided by workmen, contractors or suppliers, and arrange the contractor to execute such work or services or to supply such materials or goods. Now I will explain based on PAM 2018 with quantities based on clause 27. Based on clause 27.1, nominated subcontractor was nominated by architect referred to as nominated subcontractor to supply and fix materials and goods or to execute works and employed by contractor. If the nominated subcontractor propose an alternative design to the subcontract drawings and shall take responsibility to ensure that such subcontract works are fit for its purpose. Based on clause 27.2, the architect shall not nominate any person as nominated subcontractor against whom the contractor makes reasonable objection. The contractor shall make such reasonable objection in writing not later than 14 days from receipt of the nomination instruction from the architect. And based on clause 27.2 stated that the architect shall not nominate any person who will not enter into a contract with contractor when the nominated subcontractor carry out and complete the subcontractor works. Nominated subcontractor observe, perform and comply with all the provision of the contract. The nominated subcontractor indemnify to contractor against the same liabilities which the contractor is liable to indemnify the employer, and nominated subcontractor indemnify contractor against claims in respect any negligence, omission or other property belonging to or provided by the contractor. Based on clause 27.3, objection to nomination subcontractor. The contractor shall not required to enter into a subcontract with any nominated subcontractor whom has made a reasonable objection based on available known facts and documented evidence. Based on clause 27.4, action following objection of nominated subcontractor. First, architect issue further written instruction to remove the objection. Second, the contractor issue an instruction omitting the work which was the subject of the nomination instruction. Third, renominate another subcontractor for the subcontract works.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Shahira binti Faris and I will present about payment to nominated subcontractor or supplier. Firstly, the process of payment to nominated subcontractor and supplier is through by interim payment and value of work that has been prepared by consultant. Then, consultant will prepare the certificate containing information of work such as total price contract, value of work, value of site, operation order and total payment has been agreed. This information shall be deemed interim payment to main contractor. The client paid direct to nominated subcontractor or supplier by main contractor because agreement contract only happen in between main contractor and nominated subcontractor and supplier. It is not between client and nominated subcontractor or supplier. Then in PWD form 203A revision 1 2010 clause 61. Okay, in clause 61, the superintendent officer in issuing interim certificate under clause 28 or the final certificate under clause 31 hereof shall state separately the amount of interim or final payment due to each nominated subcontractors or suppliers, which amount subject to clause 60.2 hereof shall be paid by the government direct to the nominated subcontractors or supplier. The amount paid by the government direct to the nominated subcontractors or suppliers shall be deemed to be a payment to the contractor by the government under and by virtue of this contract. Clause ini menyatakan bahawa nominated subcontractor or supplier dibayar oleh government dan bayaran tersebut juga dianggap kepada kontraktor oleh government berdasarkan kontrak. Clause 61.2. Subject to the relevant provision in the subcontract PWD 203N or form PWD 203P as the case, the contractor shall be entitled to be paid and the government may pay to the contractor out of any money otherwise due to a nominated subcontractor or supplier. There are three conditions, which are any amounts which the government or the superintendent officer on its behalf in exercise of any rights under this contract has deducted from any money due to the contractor, and such deduction is in respect of some act or default solely of the nominated subcontractors or supplier, his servants or agent. Second condition, which Any amount agreed by the nominated subcontractor or supplier as due to the contractor, or any amount awarded in arbitration litigation in favor of the contractor which arises out of or under the subcontract. The last condition is the amount of any claim or loss and or expense actually incurred by the contractor by reason of any breach or failure to observe the provisions of the subcontract by the nominated subcontractors or suppliers under the subcontract. Then we move to the PAM 2018 with quantities, clauses 27. 27.5 is say about payment by contractor to nominated subcontractor. Okay, the architect shall direct to the contractor as to the total value of work properly executed and include the percentage of the value of the materials and goods stated in the appendix in the calculation of the amount stated to be due in any certificate issued under clause 30.0, and shall at the same time when the certificate is issued inform the nominated subcontractor in writing of the amount of the said total value. The sum representing such total value less any retention and deduction expressly provided under PAM subcontractor within 7 days after the period of honouring certificate. Dalam clause ni menyatakan bahawa arkitek akan mengarahkan kontraktor mengenai jumlah nilai kerja yang dilaksanakan dengan betul dan masukkan peratus nilai bahan dan barang dinyatakan dalam lampiran dalam pengiraan jumlah yang perlu dibayar, dan pada waktu yang sama semasa sijil dikeluarkan hendaklah diberitahu kepada subkontraktor dan juga supplier yang telah dipilih secara bertulis mengenai jumlah yang dibayar. Next, we move to the clause 27.6. It said about failure contractor to pay nominated subcontractor. The architect may at any time before the issuance of an interim and penultimate certificate request the contractor to furnish to him reasonable proof that all amounts stated as due and included in the previous certificate have been discharged. Yang mana kita boleh faham daripada sini bahawa arkitek meminta kontraktor untuk menyatakan bukti-bukti pembayaran dan juga sertifikat yang sebelum ini, tetapi kontraktor gagal. The contractor shall provide such proof within 14 days of the architect request. Kontraktor perlu memaparkan bukti yang diminta oleh arkitek selama 14 hari. If the contractor has any reason for withholding any nominated subcontractor payment under clauses 16.1 and 26.13 of the PAM subcontract 2018, he shall provide the architect written details of his compliance. If the contractor fails to comply with the architect's request within 14 days, the architect may issue a certificate stating the amount in respect of which the contractor has failed to provide such proof. Where the architect has so certified, the employer may pay such amount directly to the nominated subcontractor or supplier and deduct same from any sums due or to become due to the contractor. The architect may issue the aforesaid certificate irrespective of whether or not an interim certificate under clause 30.0 is due for issuance. Jadi, selepas kontraktor gagal untuk menyatakan bukti kepada arkitek, maka klien terus membuat payment kepada nominated subcontractor or supplier yang telah dipilih. Dan kemudian baki daripada keseluruhan jumlah akan diberikan kepada kontraktor. Next, before I go through with this clause, I will briefly explain about final payment. Final payment is a final bill on a completion of work and a full settlement of account. Final payment process started when nominated subcontractor or supplier submit their final payment application to the main contractor. After that, main contractor will bill it to the client for final payment to state that the project has been completed. So in clause 27.7, If the architect wishes to make final payment to any nominated subcontractor before final payment is due to the contractor, and if the nominated subcontractor has indemnified the contractor against all of his liabilities under the nominated subcontract, the architect shall issue a certificate to the contractor, and the contractor shall pay to such nominated subcontractor the amount so certified less any retention and deduction expressly provided under PAM Subcontract 2018. Upon such final payment, the retention fund shall be reduced by the sum of the retention released to the nominated subcontractor or supplier. The next topic is responsibility of contractor to nominated subcontractor or supplier. The contractor also contribute in legal and regulatory responsibility, which main contractor is responsible in applying the building permits and ensure that the project is in compliance with required legal and regulatory issues. 63.1 The contractor shall be fully responsible to ensure that the nominated subcontractor or supplier shall conform with the terms and conditions of this contract and shall be fully responsible for the acts, defaults, or breach of any terms and or conditions of this contract by the nominated subcontractors or suppliers on their part in the same way as for his own or those of other subcontractor or supplier engaged by himself. The government shall in no circumstances be liable to the contractor for the default of any nominated subcontractors or supplier. Next, we move to clause 63.2. In the event of repudiation or abandonment of his subcontract by any nominated subcontractor or supplier, or the determination by the contractor of the employment of the nominated subcontractor or supplier for any reason under the subcontract, the contractor shall do one following. First, with the consent of the superintendent of the SO, such consent not to be unreasonably withheld, employ any the competent subcontractor or supplier to complete the subcontract, or undertake to complete the subcontract by himself. And then, provided that in any such events, the contractor is entitled to be paid the same sum for the work or services to be executed, or materials or goods to be supplied, as would have been payable had the original nominated subcontractor or supplier completed the subcontract without any default on its part. Next, we move to the PAM 2018 with quantities in clause 27. Then in this clause, it also tells about responsibilities of contractor towards nominated subcontractor or supplier. Okay, in clause 27.9, the contractor shall be fully responsible to ensure that all nominated subcontractor carry out the subcontract works in accordance with the nominated subcontract and in compliance therewith provide designs, if any, materials, goods, and standards of workmanship of the quality and standards specified therein to the reasonable satisfaction of the architect.